All right, well, let's go ahead and jump in. Welcome and thank you for joining us for this first joint JCLS and JCLF webinar on the basics of estate planning. We're so glad to have so many of you joining us today. I'm Carrie Turney-Ross, Area Manager for Outreach and Programs at Jackson County Library Services, and I'm joined by my colleague, Jenny Ayer, the Executive Director for the Jackson County Library Foundation. Together, we're offering this webinar as a service to our supporters through the foundation and to the public at large. We're committed to the library's mission of connecting people to information, ideas, and each other. This pandemic has taken us in and out of our buildings for the past year and a half, but we've continued to provide services through online programming like this one. Just a few housekeeping tips for those of you joining us. This is a webinar, which means that only the panelists and hosts are able to turn on their cameras and microphone. Everyone else, you are more than welcome to use the chat. And if you have questions for Jason at the end, you can go ahead and type those into the Q&A. So if you go to the bottom of your screen, there should be some little boxes and bubbles that you can see. There's the Q&A, and that is where we ask you to put any questions for Jason. The chat, you can also use that if you just, if you have questions about Zoom, or if you have any, if you just want to share, this is really cool. It's a great way for you to all chat with each other. I am now going to hand it over to Jenny. So once again, thank you for joining us, and I will turn off my camera now.
Thank you, Carrie. So I think Carrie mentioned it. We'll have time for questions at the end, and also an opportunity for you to see both my contact information and Jason's if you'd like to reach out to us. The Jackson County Library Foundation provides funding for programs that go beyond what public funding supports. So keeping our community connected has never been more important, as I'm sure you all know, than throughout this pandemic. And the foundation has supported some very unique programs that are making a difference during this time specifically. The DART van, it's a tech van, a mobile tech solution that bridges the digital divide in Jackson County, offering services on the go like web Wi-Fi access, tablets, laptops, and even tutoring on how to use that technology. And I'll just take a moment to mention that the funding that the foundation was able to provide to the library for the tech van came from a bequest, the Owens bequest. So it's important to recognize that those charitable gifts that people choose to give during their estate planning really makes a difference to the community and provides a legacy that that changes lives. We also support a social worker through a grant from Oregon Community Foundation, and recently from All Care is supporting some of the things that are provided to folks that the social worker is helping. This new position is helping some of our most vulnerable community members find resources, patrons looking for employment, mental health services, food, shelter, and even social fulfillment through volunteering are being helped through this new program. Rogue Reads is coming up. Maybe Carrie will say a few words at the end about that. We have 3 books. The first is Braiding Sweetgrass. That's the adult book that everyone is reading. I'm in the middle of reading it right now. It's really good. So it's a community read, an opportunity for lots of great activities that the library has provided to go along with those. And so I hope you'll join us for that community effort as well. And that's something that the foundation is supporting through the charitable donations that come through to us. And Baby's First Book is another program that's a favorite, getting books into the hands of those young babies before so that they can enjoy lifelong learning. So connecting people all the way around. As I mentioned, bequests are a big way that the foundation provides and serves our community through the library services in ways that public funding does not currently carry on. And with that, I'm going to ignore my phone in the background, which I should have silenced. And also just take a moment to have you take a look at the disclaimer and introduce you to today's guest, Jason Broesder, attorney at law. Jason was born in Malta, Montana. He received a BS in finance from the University of Wyoming and then completed his JD at the University of Wyoming College of Law. And Mr. Brewster is a member of the Oregon State Bar, the Jackson County Association, the National Association of Elder Law Attorneys, a former adjunct professor of business law at Southern Oregon University, and also serves as a judge pro tem. Jason's engaged in local high school sports as he is the color commentator for Crater Basketball on behalf of Table Rock Sports, tablerocksports.net, he says. His favorite activities include spending time with his wife, Chelsea, and visiting his two oldest daughters who live out of state. His son, Tate, keeps Jason and Chelsea busy following his sports and activities. His family enjoys wake surfing and golfing together. We're so pleased to have Jason with us today. So thankful that he's willing to share his expertise, because one of the things we also know is that Googling of wills has gone up by 50% in recent months during this pandemic. So we know it's a big topic. It's something that people are really interested in knowing more about. And so with that, I'm going to turn it over to Jason. When he's done, we'll have some time for Q&A. Feel free to put those notes in the chat and in the Q&A, and Carrie will run us through those at the end. Thank you. Welcome, Jason.
Thank you, Jenny. Nice introduction. And I've already learned something. I did not realize that Googling wills or estate plans has gone up 50% during the pandemic. That's shocking to me. In a way, it kind of makes sense because I think when this pandemic started, a lot of us were really unsure what the future was going to look like. And I guess in a lot of ways, we're still a little bit unsure what the future is going to look like. But I appreciate Carrie and Jenny giving me the opportunity to talk to you today. I'm not in Hawaii. You probably already guessed that. When I originally set Zoom up, which was right as the pandemic was starting, gosh, almost 2 years ago, I think it was March of 2020, March of 2020, I guess it was, that this all started, and we decided that we needed to learn how to use Zoom. I put a virtual background up, which was a picture of a golf course in Hawaii. And for some reason or other, I haven't been able to figure out how to take it down. It hasn't bothered me enough at this point to call in my technical support to get it down. So I'm just sitting in my office, and you can see Hawaii in the background because it's better than looking at my messy office. So I appreciate the opportunity to talk to all of you today. This is kind of a strange Zoom call for me because I don't see anyone. All I can see is the slideshow, which is a big picture of my name and says that I'm an attorney at law. And I am an attorney at law. I've been practicing here in Southern Oregon now since 1999. My wife and I and our then only daughter, but our oldest daughter, who's now 24, we moved here from Wyoming after graduating from the University of Wyoming, and I've been practicing primarily in the areas of estate planning and elder law since 1999. So what I want to talk a little bit about today, I'm going to go through kind of some of the basics of estate planning. I'm glad that Jenny put up the disclaimer that was on before, because everybody's situation's a little bit different. What might seem perfectly fine for your neighbor or your parents or your kids or your siblings may be an inappropriate estate plan for you, or you might need an estate plan that would vary from that. So I'm going to give kind of some basic general ideas, and then if you'd like to, again, I'm happy to answer questions regarding those ideas towards the end of the Zoom call. And I have an 11 o'clock appointment, so I'm going to try and be finished wrapping everything up by 10:45, and then leave some time for questions and answers after that. So the basic idea, the main reason why we do estate planning is to plan for the future. And it's not always just planning for death. Some of the things that we need to prepare for are incapacity as well. Who's going to take care of our children if we have children that are younger or minor children? Who's going to manage their finances? Who's going to take care of or manage the finances for our children that might be older but might have special needs? So those are some of the issues that we deal with on a regular basis in my estate planning practice. So the first thing that I want to talk a little bit about is a durable power of attorney. This is usually the part when I'm talking to people when I say by raise of hands who's familiar with durable powers of attorney, and most hands go up because most everybody has heard the term power of attorney or is familiar with what it means. So I'm going to talk a little bit about how powers of attorney fit into my estate planning process. Typically, I'm dealing with spouses, husband and wife, who have children or other people that they want to plan for. But one of the things that we want to talk about is what happens as we age if one of the two spouses or partners becomes unable to manage their affairs. We want to have the flexibility to be able to possibly transfer assets, to prepare for long-term care expenses and that type of thing. So usually the tool that we'll use is what's called a durable power of attorney. Now, in Oregon, all powers of attorney are durable unless they say otherwise. So that brings the question, what does it mean to be durable? Durable in the context of powers of attorney is referring to the power of attorney remaining in effect even if I should become incompetent. So if I appoint my wife to be my durable power of attorney and I suffer a stroke or develop a disease, Parkinson's or dementia or something of that sort, where I have cognitive impairment to the point where I cannot write checks, I can't manage my finances, I can't do a lot of those things that are necessary, then my wife, as my durable power of attorney, has the ability to step in, pay bills on my behalf, transfer assets, take care of legal issues if there's credit cards or retirement accounts that need to be transferred, that type of thing. That power of attorney gives her authority to manage my finances and my legal affairs as necessary. I just realized it's just kind of a weird time of year, and the sun has decided to make an appearance for the first time in what seems like weeks anyway, and it's giving me a bad glare. I apologize for that. I don't have on my upstairs windows where my office is, I don't have shades, and so we'll just have to live with that. Sorry about it. I'm not glowing or nothing strange is happening, just the sun coming through the windows behind me. So the power of attorney allows the agent, the person who's been appointed, to manage your legal, financial, and tax matters, even if you become incompetent. Now, it's important to understand that powers of attorney terminate upon death. So if I die, my wife cannot use the power of attorney and go into the bank or go to DMV and transfer my accounts or sell my car or something like that, because that power of attorney ceases upon my death. The other thing is powers of attorney are freely revocable. So if I appoint my oldest daughter to be my agent or my attorney in fact, and I decide that I don't trust her, or I don't think she's making good judgments or something like that, I can always fire her. I can always revoke that power of attorney as long as I've got the same capacity that I had when I appointed her as my agent, my power of attorney. So hopefully that makes sense to you. So powers of attorney, even if they're durable, even if they last beyond incapacity, they fulfill a very specific role, and that role includes taking care of legal and financial affairs upon incapacity, but prior to death. They're no longer any good once the principal, the person appointing the agent, has died. So that's powers of attorney generally. And I think that in all estate planning situations I've run across, that's something that we've just recognized is necessary and important. It's one of those tools that aren't always needed, but when they are needed, they're super important, because the alternative, if I don't have a power of attorney and I've got assets in my name and I become incapacitated or incompetent, it might require somebody to go to court and go through what's called the conservatorship process, possibly guardianship, most likely conservatorship if they want to manage my assets, my financial assets. And that can be quite expensive. It can be expensive, it's ongoing, it's public, there's bond requirements. So the alternative to the power of attorney can be an expensive and sometimes frustrating proceeding, because it can also, in order to get conservatorship, it might require my daughter to file an action, and it's technically an adversarial action against me, saying that I'm financially incapable. And if she's wanting guardianship also, she might be saying I'm incapacitated. And that may not sit well with me. If I object to it, then my daughter and I are going to be in court battling out whether or not I've got my wits about me. And I've been in a lot of those hearings, and they're seldom pleasant by any stretch. Nobody wants to admit when they've got cognitive impairment. And so I think reasonably, a lot of people will fight over it, and to, keep their autonomy, keep their control. So hopefully that makes sense to everybody. I'm going to move on from powers of attorney and talk about something similar, but kind of related differently, and that is advanced directives. So advanced directives are really a lot like the power of attorney, only it's for medical care. So with the advanced directive, kind of in that same tone, I would be appointing a healthcare representative, somebody who's going to speak to the doctors on my behalf in the event that I'm not able to give direction regarding my medical care. And this is a really important point. As long as you're competent and capable, you have the right to direct your own medical care. But if you're unconscious, or if you're not receiving and evaluating the medical information that the care providers are providing to you and making decisions, based on your ability to receive and evaluate that information, they may seek a healthcare representative to make that decision on your behalf if it's clear that you're not able to. And so with the advanced directive, the reason that's important is because we know who we want to make those medical decisions for us. My wife would be my first choice in most situations, but I've got 3 kids, and my 3 kids all see things a little bit differently. They'll all miss their dad to a greater or lesser degree if I'm in the hospital, and one or more of them may not be able to make that decision regarding tube feeding or life support. So you need to think through who's going to make that decision for you, who's going to advocate regarding your health care if you do end up in the hospital and there's a question regarding tube feeding or life support or other types of decisions that you might need. Now, the advanced directive in Oregon, it's a statutory form, meaning that the language in the advanced directive is straight out of the Oregon revised statutes. It's changed quite a bit, actually, just in the last few years. There was a pretty substantial change, I guess 4 years ago or so. And I thought that was going to be one that we were going to stick with for quite a while, but there's been actually another recent change that's been even more substantial, and that was just a couple months ago. The form has gotten quite long. It's now, I believe, 9 pages. It does still deal with tube feeding and life support, but I think the language in it has gotten a little bit better to follow and better to understand. The initial advanced directive that was from the 90s was frankly a little confusing. And I think the new form, even though it's gotten quite a bit longer, I think it's in layperson terms. I think that it's much easier for people to read through and determine what it is they want. But the gist of it is still the same. With the advanced directive, the first part of it, you choose who you want to be your healthcare representative, who the person that you want to speak to the doctors and nurses if you're in that situation, and who you want making those decisions for you. And then it walks through 4 different scenarios discussing whether or not, if you're in any of those hypothetical situations, whether or not you would want tube feeding or life support. It also talks about, you know, any kind of spiritual choices that you might have. It talks about blood products and whether or not you would be willing to undergo a transfusion and some of those things. So there's a lot to unpack in the new advanced directive. It's not fun stuff to talk about, but the way I look at it is filling out the advanced directive is really kind of a gift to your loved ones, because the real painful decisions are the ones where the kids and the spouse, especially in the situation of a blended family, are at the hospital together trying to determine together what you would want done regarding your future, regarding the tube feeding, the life support, and that kind of stuff. And so I think that preparing the advanced directive, executing it, and having it on record is something that's helpful for them, because then there's no debate, there's no discussion, there's no argument, no fights about what you might have wanted, because it's all laid out. The advanced directive does need to be signed in front of either a notary public or 2 witnesses. So that's kind of the key, is it wants to be properly executed to make sure that it was you who signed it, and that that you were competent and capable of understanding and signing it when you did so. And then the people that you appointed as your healthcare representative and your alternate and your successor healthcare representative, they should also countersign on the back of the advanced directives. And I think the advanced directive forms, most of you would find that that it is available in your doctor's office or the hospital. Usually they keep a bunch of those on hand. If I had to guess, I would bet a lot of them don't have the updated advanced directive, just because it's so fresh and new, but they should be circulating here within the next couple of months. So I would anticipate that they're going to be out soon. And anticipating the question of, do we need to update it just because the form's updated? The answer is no, you don't need to. You might want to take a look at it to see if there's something in there that you like or that you want to change. But your old advanced directive, if it was properly executed, is still in place. It's still in effect, and it will still be followed. Same thing if you moved here from a different state. If you moved here from California and you had a healthcare power of attorney and a living will, or a California advanced directive, or whatever the case might be, those are still in effect when you move across state lines. That said, I always recommend to my clients that they still update their advanced directive with the Oregon form if they're still able to. The reason for that is our doctors here, our hospitals here recognize the Oregon advanced directive. They understand it, and they are more capable of kind of following what the purposes of it are because of their familiarity. So that's the advanced directive. Not to be confused with the post form. The post form, some of you might be familiar with, that's the bright pink form. That's kind of the classic DNR form, the do not resuscitate form. That's the one where you can make a decision about whether or not you wish to receive chest compression, CPR, intubation, that kind of thing. You know, if the ambulance, the EMS shows up and you're unconscious, the post form dictates to them whether or not they should take the measures necessary to keep you alive or help resuscitate you while they're trying to get you to the hospital. So the post form has to be signed with your doctor, because it's a physician's order regarding life-sustaining treatment. The advanced directive is your directive to the doctors. And here's how the interplay works. The post, like I say, is basically for the emergency medical service providers. That's the doctor, your doctor, telling EMS what types of measures they should or should not take to keep you healthy or alive to get to the hospital. Once you cross the threshold of the hospital, you're under the care of the attending physician at the hospital. That's when your advanced directive takes over. So the post basically gets you to the hospital. The advanced directive is once you're in the hospital. So you want to have both of those on file. You want your primary care doctor to have a copy of the advanced directive. And if you fill out the post, it goes into the central database so that the ambulance drivers can pull those up in their computer in the ambulance on the way to come see you, come say hello. So that's the advanced directive and how it interplays with the post. I hope that kind of makes sense to you. All right, so I've got about 20 minutes and I kind of want to dive into wills and trusts a little bit. That's probably the most frequent question that I get from my estate planning clients is, should I use a will or should I use a trust? Which one of them do I need? And I try not to answer the question on my client's behalf, but rather explain to them the differences between wills and trusts, and then kind of try to let them make the decision on their own. Now, there are some circumstances where I think a trust is necessary or certainly the more beneficial instrument. And that would be if you own real estate in Oregon and you own real estate in another state. If you own real estate in Oregon and you own a house or something in Nevada or Arizona, I think a trust would be valuable because it will definitely substantially reduce the expenses and the hassle of estate administration after you pass away. The reason for that is if you have a will and we probate the will in Oregon, Oregon courts don't have any jurisdiction over the Arizona real estate, so you'll have to do yet another probate in Arizona. So it could be 2 or more probates depending on how many different places you own real estate in. So that's the only time that I really say you should definitely consider a trust because you own real property in multiple states. So I kind of gave you a little sneak preview of one of the downsides to the will, and that's probate. But I want to talk a little bit more about probate just so you kind of have a little bit better understanding of it. So to kind of compare and contrast the will and the trust, wills in my office generally are about half as expensive as trusts. Actually, usually even a little less than half as expensive. We'll say maybe a third of the cost of trust, just because there's always recording fees and stuff like that involved in setting up revocable trusts. So the will is less expensive on the front end for the testator, the person who's signing the will. The downside, if you consider it a downside, is that the will is going to be more expensive after the testator dies than the trust administration, if the trust is properly funded. So I'll get into that a little bit more. But basically, if I set up a will, and we'll assume that my wife has predeceased me, not because I hope that happens or anything like that, but just for the sake of this hypothetical, because it works a little bit better. So upon my wife's death, everything just automatically went to me. We didn't even need her will because we own everything jointly. We've got joint bank accounts, our cars are held jointly, our house is joint. And so it just all passed to me. Then upon my death, my oldest daughter, who we'll say is my executor, is going to need to hire an attorney and file a petition for probate with the court, because my will says I nominate my daughter to be my executor or my personal representative. Well, that just says I nominate. A court has to appoint her. The reason for that, there's several reasons. One of them is that formality of going to court allows my other 2 kids to step forward and say, hold it, I've got a more recent will that actually appoints me as the executor of the estate. So it allows the judge to determine what was Jason's last will and testament. So we know for sure that we're going to be dealing with the last will and testament. We know who's going to be responsible, the testator, or excuse me, the executor, or the personal representative. And we know how the estate's going to be distributed. So That's one of the benefits of the will, because there's no question about, well, was there another will? Was there another document signed after this one? The downside is it's going to be relatively expensive. My daughter, since she's hiring a lawyer, after the lawyer's fees and the court fees and all that stuff, the probate's probably going to range somewhere between $5,000 and $10,000 in cost. And what that means is that my 3 kids will get $5,000 or $10,000 less than they would have otherwise. Which to me, I might be saying, well, that's fine because I saved some money on the will and they're still getting a bunch of money anyway. And so what do I care? I'm not interested in spending a bunch of money while I'm alive just to try and save them money after I die. That's how some people view it. Others see it differently. Others say, well, I want to make it as inexpensive and easy as possible for my kids after I die. So there's some expense to the probate, but there's some value to it also, because it's most likely the first and only time that my daughter will ever be administering an estate. And if that's the case, she may benefit from the assistance of a lawyer. The lawyer will help her walk through the process of making sure that my final tax returns are prepared, making sure that all my creditors are paid, dealing with any issues if one of my other kids decides that they're going to be difficult for my daughter to handle. So there's a lot of things that I guess I should say, there's a lot of value at times to having a lawyer help walk a person through this estate administration process. Again, there's expenses, so there's a trade-off to it, but you know, I've administered enough estates to where I've seen there are definitely some estates where it's helpful to have a lawyer on board helping walk the personal representative through the process. Not trying to sell you on the will or sell you on paying lawyers a bunch of money or anything like that, but you know, we've been around for a long time. We'll be around for a long time because we have some special skills that help people in certain circumstances in their lives. So let's contrast that with the trust. So with the trust, when I set it up in the first place, like I said, it's probably going to cost at least twice as much as the will. And in addition to setting it up, I need to make sure my house gets transferred in the trust, my bank accounts, my investment accounts, and a lot of those other assets that I have, maybe my boat, my RV, the other stuff that I might own, all should get transferred into the trust to make sure that we avoid probate, because whatever's not in trust is potentially a probate asset. Now, there are some exceptions. Some of the exceptions would include life insurance accounts, retirement accounts, annuities. Typically, those have beneficiary designations, and we don't want to put those in trust for tax purposes. We just want them to go to the beneficiaries that are named on there. So that's kind of a little bit of a tricky part with the trust, but as a general rule, we want to make sure everything goes into the trust. Then, assuming that the trust is fully funded upon my death, my daughter will probably still see a lawyer, but rather than paying between $5,000 and $10,000, she'll probably be paying the lawyer between $500 and $1,000 just to kind of get her started with the trust administration. So the trust administration generally will be less expensive as long as it's funded properly. If it's not funded properly, then she's going to have to do a probate anyway. And that's going to be, you know, she's going to go through all that expense. Plus, I went through the expense of setting up the trust in the first place. So I always tell people a trust can be beneficial, but it's really important that you understand that it needs to be funded. And if it's not funded, then you're losing the benefit of the trust. So hopefully that made sense between the trust and the will. Like I said, there's a lot of nuance there. Everybody's family is a little bit different between the capability of the executor or the trustee on the trust, the beneficiaries, whether they're inclined to fight with each other, whether they're minors, whether they're majors, all that stuff that's all going to come into play when making a decision about setting up a trust or signing a will. And I should talk a little bit about that. With minor children, we can do with wills about the same as what we can do with trusts. And what I mean by that is this. When I say trust, like what I've been talking about, what I'm referring to is what's called a revocable living trust. Revocable meaning I can change it or modify it as long as I'm alive and competent. Living meaning I set it up during my lifetime, as opposed to what's called a testamentary trust. So I can set up a revocable living trust that goes on even after I die to take care of paying bills and paying for college and stuff for my children until they attain a certain age, and then the money will just get paid out to them. Or I can provide for them in my will, where I say, well, I'm going to leave everything to my 3 kids. But if any of them are under the age of 18 or under the age of 25, I want to nominate so-and-so to be the guardian for my children and also to be the trustee for my children. So instead of a revocable living trust, I'm establishing a testamentary trust, which says it's not going to get set up until I die, and only if my children are under a certain age, say 25. So that's a testamentary trust, because it may or may not actually get set up, because my kids have to survive me and they have to be under the age 25 before that trust gets established. If they don't survive me, or if they're 26 or older, then the money's just going to go outright to them. So hopefully that makes sense. But my bigger point there being that we can do with the will just about everything that we can do with the trust. And I'm going to just touch a little bit on estate taxes right now. Everybody's least favorite topic, or probably at least on the list of least favorite topics. So Oregon's kind of behind the curve on estate taxes. Most states have a higher tax threshold than Oregon does. In fact, I think Oregon might be the lowest tax threshold. Right now, Oregon is taxing all estates that exceed $1 million in assets. So what that means is if you have $1.5 million, the 500,000 above the 1 million is going to be subject to Oregon's estate tax. It's not subject to federal tax. The federal government exemption amount is much, much, much higher than that. If you're a married couple and you plan correctly, it's possible to use both of your $1 million exemptions and actually have up to $2 million total exempted from Oregon estate taxes, but you have to go through the proper planning with that. It's not too difficult, but there is some sophistication to it, and you have to do some planning and taking care of things ahead of time and after the death of the first spouse. So Oregon has made it a little bit more difficult to die with larger assets or larger estates without the estate tax applying. And it's taxed, I think, generally at about 10% is the Oregon estate tax. So it's not a huge percentage, but at the same time, you know, I don't think anything that anybody wants to pay. And it really is a true double tax, because those assets that you have in your estate, presumably you paid taxes on them when you first started acquiring assets, and or on their growth, and then your estate again pays that estate tax after your death. Special needs. That's another issue. I've got just a few minutes here, and it looks like I've got a couple of questions in the queue, so I'll try and pull those up as soon as I finish this. So if you have a child with special needs, or whether they're an adult or a minor child, you definitely need to talk to a lawyer about how to handle that, because some planning should take place to determine, do we wish to try to keep that child's needs-based benefits, whether receiving Oregon Health Plan or food stamps or HUD housing or Social Security disability, any of those things. If you want to try to preserve those, then you need to take some steps within your estate plan to do that. You might leave that child's share to a different child that you know will take care of him or her. Or you might set up what's called a special needs trust or a supplemental needs trust for the benefit of your child with special needs, so that he or she does not lose those needs-based benefits. So you can work it so that those benefits stay in place, but you're going to have to work within the parameters of the special needs laws. There's also what are called ABLE accounts, ABLE, all caps ABLE accounts, which are really, really nice tools that are fairly recent. And I would encourage anybody who's got special needs children or loved ones to take a close look at whether or not they would be eligible for the ABLE accounts. Mike says, does pay on death designation for financial accounts and transfer on death deed for personal residence eliminate need to have will probated, assuming no disagreement between heirs? Excellent question, Mike. Those are good tools to use in certain circumstances. I wouldn't use them in large family situations because they're kind of fast and loose, especially the POD accounts on the financial accounts. They're really good if you've just got one or two kids, one in particular, because it's all pretty straightforward. Transfer on death deeds, I had a lot of hope for those when they first came out a few years back, but I don't like them. I don't care for them because title companies got involved. Sorry if there's any title company people out there, but they got involved in the writing process of the statute. And as it turns out, when you are a beneficiary of a TOD deed, a transfer on death deed, you can't sell the home for 18 months after the death of the transferor, which is fine if you're planning on keeping the home or if you're already living in the home. But if your goal is to turn around and sell it, you're going to either need to deal with the title company, possibly pay a premium on the insurance, or probate the estate anyway. At any rate, I was hoping TOD deeds would be a good estate planning tool, and they have not been as good as what I was hoping for. That's my answer on that. Okay. How to handle a vehicle title, which is name of deceased spouse. Okay. That's actually pretty easy. Again, not looking to offend anyone that works at DMV, but the one thing DMV does well, the only thing DMV does well, is they transfer vehicles upon a deceased person's passing. You take in a death certificate, you can sign an heirship affidavit, and they'll take care of transferring the title pretty easily. Now, you could run into a problem if that deceased spouse had children that are not your children, like a blended family, because it may not be that you're actually completely entitled to be on that vehicle. You might have to share the car with that deceased spouse's children. At any rate, kind of an insult, kind of a compliment to DMV. They handle transfers of titles really well, and I'm not sure what else they handle really well, but that they do. Wow, somebody's just checking these off as I go. I'm going to guess that's probably Carrie or Ginny, but nice work. Okay, so this is from B. I created a will with an attorney in 2019, but would prefer to have it transferred or on file with a different attorney. What is the procedure? Thanks. Good question, B. So here's the thing. This might be a revelation to a lot of you. I don't own my clients' files. Yes, I might own the paperwork and that kind of stuff, but when you hire a lawyer, the file actually belongs to you. Now, I can't help you with the awkward phone call or email. I've received them. I've been on both ends of them. Lawyers, I think most good lawyers just understand sometimes it's not a great fit, or you find another lawyer that you just like better. I've never gotten too worried about stuff like that. I realize some people like me, some people don't. It's not much you can do about it. So what you can do is just email your old attorney and say, I'd like to transfer my files to so-and-so, a new attorney, and maybe copy that attorney on it. The other thing though is most, well, I shouldn't say most, it probably is most attorneys like myself don't hold original wills or trusts, because if we do, we're required to keep them for at least 40 years. And I don't know what my status will be in 40 years, but I'm 51 now and it may not be great. But I'll definitely not be practicing law in 40 years. So what I would say is, if you've got an original will, and I've had this happen a lot, just bring it into the new lawyer and then you've transferred your file effectively. Because I talked about the probate, they're going to figure out which was your last will. That's what the whole probate process is for. So I've had a lot of clients come in with original wills done by other lawyers, and we just do a new one. And it's just no big deal. Lawyers, like I said, they should not be too worried about transferring files. If they do, then they're probably in the wrong business. All right, Karen, you mentioned funding a trust. Is that an ongoing fee? Good question. So it's usually not, because after I transfer the house into the trust, I just give my client instructions and tell them to go fund it. The main thing is making sure that the client understands what funding means. Transferring the bank accounts, transferring the mutual funds, transferring stocks, those kinds of things. That's what the funding process is. But it would be expensive to have me traveling around with my clients to their banks and to the Smith Barney or whoever to have them walk them through the funding process. Typically, I'll just give them a certification of trust and tell them, make sure to take this to your financial planner and they'll help you with funding it. And they do, they all understand it. So no, not an ongoing fee. Ooh, can you go back one for me? I didn't answer the rest of her. She had a two-part question. She snuck in a second part. Might be too late.
Sorry, I can read it out loud for you.
Okay, yeah, go ahead. What was the second part?
Does estate tax over 1 million include real estate?
Yes. Okay. Yep. Yes and yes, it does. Estate tax includes, well, think of it. There are taxing agencies like the Internal Revenue Service, like the Oregon Department of Treasury. They will include everything. That's what they do. All right. Should we reverse TOD on personal residence if immediate sale is planned? Probably. Like I said, Mike, I don't love TOD deeds. I've done one of them since they've been out, and this was a situation, I think it was in Ashland. Mom and daughter lived in the house together. It was mom's house, and she wants daughter to have it. Daughter's her only child, and daughter's planning on living in the home forever. And so the TOD deed seemed like a pretty good solution in that situation. If the main reason people have TOD deeds is to avoid probate. In my opinion, a trust is just a better tool to avoid probate than a TOD deed is. Yeah, I know it's more expensive, but it just works better. The threshold for probate in Oregon, this is from Mary Beth. Good question, Mary Beth. What it is right now is, first of all, it's got to be a probate asset. So that would be an asset that's in Mary Beth's name only, with nobody else on it as a co-owner with right of survivorship or a beneficiary designation. So no TOD, no POD, nothing like that. It's just in your name. It can be a house, it can be a car, it can be bank accounts. Personal property up to $75,000 in value. Personal property includes vehicles, cash, bank accounts, mutual funds, stocks, bonds, that kind of stuff. That's all personal property. Personal property is basically anything that's not real property. So up to a value of $75,000. If it's over $75,000, then it's a probate. Plus real estate with a value of $200,000 or more. And frankly, right now it's hard to find real estate in Oregon that's valued at less than $200,000. So if you're over $200,000 in real estate and or $75,000 in personal property, you're in probate territory. If it's under that, you can do what's called a small estate affidavit, which is less expensive, kind of like a probate light, less expensive, less formal, less lawyer involvement, which is why it's less expensive. Well, I hope this was beneficial to all of you. I hope that you learned something. Like I said, I learned something right off the bat, and that was the huge jump in Google searches for wills. In a way, it wasn't a surprise, because when the pandemic hit and we were to all stay inside for 3 weeks to stop the curve, to flatten the curve, that's what it was. I didn't know if I was still going to be in business. I thought, you know what? I may never see anybody again. I mean, like, clients might not come in to see me. And the exact opposite happened. I got so many phone calls because I think everybody started really contemplating their mortality. And I just had a ton of people wanting to come in and get their wills or trusts taken care of. And so it doesn't surprise me that people are looking closely at these things. It's my hope that that we will get this pandemic behind us before too much longer, and that I can start to see people face to face for this kind of thing. But I appreciate the invite from Ginny and Carrie, and wish you all well.